Um, all right. Well, my name is Savannah Quintero. I'm an attorney at Legal Aid Society. I get to do reentry all day for my job, which is, kind of a dream. But we do a lot of expungement. So I'm going to start talking today about non-conviction expungements. We'll go through kind of the forms you use, different processes that'll happen for non-convictions. And then we'll have Joy come in after we wrap up non-convictions, and she'll speak more to the process that we have for convictions. So without further ado, just a little note on why this is important. Folks have um, a record can really hold you back, right? So I think that probably that's pretty intuitive for most folks that it might prevent you from getting housing, a job. It could prevent you from driving. It could prevent you from kind of moving forward with your life. So providing the opportunity to folks and the ability to expunge their records is a huge deal. It can really make a difference for folks to move on and really, be able to fully participate in their communities. So expungement clinics like this one that Andy's putting on it's a big deal. So our plan today, we talked about a little bit, but we're going to start with non-convictions. We'll move to convictions. But first, let's start with what is expungement. In Tennessee, it's the process of destroying. It's kind of a two-part definition, but public-facing government records. We're destroying those during the process of expungement. Those. So what that doesn't mean, right, is not government records are not destroyed. And the government may keep some non-public facing records. There's a definition in the statute, which we're pulling all of this from one kind of long mega statute. And in that kind of mega statute, there's a definition about what is a public record and what they'll expunge. And they talk a lot about what's not a public record. So here you can see on the slide, it's not kind of confidential information kept by law enforcement agencies. DCS might keep some records if DCS is involved in a case. But things that are not public facing might be kept by a government agency. I think it's really important as we move forward to center ourselves in what we're trying to expunge, because that'll set us up for the process that we want to use to expunge. There's three kind of separate buckets I think that we need to make sure we're keeping distinct, because the process will vary between these three buckets. So first we've got our dismissals, and you'll see other words for this. We'll talk later about what other words kind of indicate a case has been dismissed, and we can use our dismissal process for expungement. The second is pretty similar. If you've served a diversion program and you were successful in it, it's pretty similar, but there's enough differences from dismissals that will separate that out into its own bucket so that we can make sure we're correctly expunging records of a successfully served diversion. And then the last bucket, which Joy will cover, is convictions. So those are cases in which you've been convicted of a crime. And that process is just a little bit different. So as we move throughout this process, we're going to keep these beautiful and separate so that we don't use the wrong process or think about the wrong parts of the law to expunge a case. So I think our first step in expungement is making sure that we know how to read the record, which seems like it's a pretty simple, it might be a pretty simple self-explanatory thing to do, but across Tennessee, the records will look different based on what county you're in. And I'm going to show you kind of the different ways that records can look. So this is an example of what the records look like in Knox County. This is what they look like in Davidson County. Um, this is the kind of what you'll see for Madison County. I call this a party detail report. By the way, the records that I'm sharing are dummy records. I'm not sharing you records of a real person, but we'll follow Bill Smith throughout this training, and he's going to be our kind of dummy client. So, but this is how the records will look in Madison County, and generally, I think most of the counties that are not Davidson, Knox, Shelby, most of the counties outside of those will look this way. So I want to focus on this and make sure we're centered in this. And you'll see too, what were some big things that we're looking for. The disposition listed, the kind of case it was. It's helpful. They'll tell you if it's a misdemeanor sometimes. You'll be able to see if it's a misdemeanor or a felony, what class. We've got a filing date, which we'll need. And then I like that they show the TCA code too, because that'll help us if it's a conviction, kind of look up and figure out if it's expungible. But anyway, this is what it'll look like in Madison County. And this is what it'll look like in Shelby County. They, again, Knox, Davidson, Shelby have their own databases. And it's just important to make sure when we're, practicing in a new county or expunging in a new county, that we kind of, figure out how to read the record. So that's what they look like. Not every single record that you might receive or be able to search online or receive from the clerk's office will have costs attached, and we'll talk about why it's important to know about costs during the expungement process. So this is what a cost sheet might look like in Davidson County. A lot of times in the Madison County records, the party detail reports that we pull, they'll have like a total on the party detail reports for costs owed. Depending on how you're helping someone, you may want to pull a cost sheet from that county, but generally that's listed on these party detail reports. In Shelby and Knox County, I know you'll have to kind of pull costs separately if you're using their online systems. So just make sure we're watching out for costs, and that that'll be an important part of whether or not we can expunge something. So we have a form in Tennessee that we use to expunge non-convictions. We're going to use this same form for our non-conviction bucket, or our dismissal bucket and our diversion bucket. A little bit different information that we'll input, but we'll use the same form. This is what it looks like. So something that I'll note too, Andy has set up this document process to fill out this form, which I think is going to be a really beautiful way to fill this out, because it asks for duplicate information kind of over and over and over again. Particularly if you're, filing some sort of affidavit of indigency with it, you'll write your client's name over and over and over again on these forms. You'll write the docket number over and over and over again, but Andy's kind of built a process to kind of help us not have to go through that, make our hands less tired maybe. But so we're gonna make sure we have our name in 3 different spots. We're gonna put some demographic information. We're gonna make sure we have our docket numbers. Something that I think that's important, if you have a case in circuit, you might want to also make sure you have your general sessions number on there so that you make sure you expunge all of those records tied to a case that was dismissed. We're going to make sure we're in the right court. And then you'll put your charge on there. You'll put it on there twice in each box. If at some point the case changes, then we're going to make sure it changes on the form as well. If it doesn't change, then we'll just put the same charge twice. We'll put the disposition, and then we'll make sure and check a disposition box down here. So this is the form. Once you get to know it, it's less challenging. So let's go over and make sure we can pull all of our information from the, and again, this is how it'll look kind of in Madison County. But how are we going to pull and make sure and find the information that we need for the form? We've got our case number up here, so we're going to make sure that follows us into the form. We've got our charge right here, so that's followed us into the form. It didn't change, so we're going to make sure it stays the same. The date of arrest, 6/19/2021. We've put that over here. We and then we know we're making sure we've got our court, the filing date as well. You'll find that on here on these records. And it was dismissed, so we're going to mark our dismissed bucket. There's a place to sign at the bottom. So another thing that we want to make sure, we talked about pulling cost sheets. We cannot expunge even these dismissed cases if there's costs on it. So we want to make sure that we're looking out for costs during the expungement process. And when you're looking at a record, if you see a disposition that says dismissed on costs, that's a pretty good indication that we want to make sure and see if there's any costs owed. A lot of times people assume or ask about, hey, it was dismissed. Why do I owe costs? Or they're surprised that there are costs on a dismissed case, but there can be. And you'll see a disposition like this, dismissed on costs, and that's a pretty good trigger to make sure. You should always make sure that costs aren't owed before moving forward, but that's a good trigger, and we need to look out for costs. There's also kind of a whole host of words that mean dismissed and that mean we can use this this form that we went over. We've listed some of them there, but so we're not just looking for the word dismissed on our record. We're looking. We can look for nollie pros. You may see no true bill. We can see maybe lots of different words that maybe mean we can use that form. Practicing just a little bit. We have, you see, 3 different charge lines on the form. So we can put up to 3 different charges on the same form, so long as they share these filing dates. You can put, multiple docket numbers on here, but it might help save you some paper to go ahead and put a couple different cases on the same form. And you just do the same thing. You'll just make sure that charge 1, charge 2, and final charge 2 match. But so here's where we pulled it from. We've got our case number up here. These are from the same case. They've got the same case number. And we see we have 2 different charges. They have the same filing date, May 2nd of 2011. We've got a criminal trespass and a possession of drug paraphernalia. And we can see at the bottom here, and that's another good thing to know with these records that look like this that we'll use in Madison County. You may not see the disposition in the little box, but they have extra information on these forms in what they call the rule docket. So in the rule docket, and you may see up here, RDE, rule docket for disposition, it may tell you right here that you need to check the rule docket to see what happened to a case. So we can see down here in the rule docket that was dismissed, and we can use our dismissed form. And same thing over here for our criminal trespass. So we'll go ahead and put both of those cases on the same form. We'll check that they've been dismissed. We'll put all of his demographic information on there, and we'll be in business. Another thing to look out for, is retired cases. Um, these are cases in which uh, a disposition's not been entered yet. They've said kind of a lot of times they'll say, you know, stay out of trouble for the next year, and come back and we'll dismiss this case for you. Um, so we do need to do a little bit of extra work that'll vary by county in dealing with these retired cases. Um, in some counties, they kind of have like an automated process where they say, uh, courts will have a standing order that says, if this is more than a year old, um, and there's been no movement on this case, you can fill out this form, the DA will sign it, and we'll go ahead and expunge it, or dismiss it so that you can expunge it. So I think that when you're in whatever county you're practicing, I would check in with the court, with the DA's office, and see if there's been some process to automate um, the process for dismissing these so you can expunge them. Um, some courts, you'll need to file a motion to dismiss, get on a docket, and go to court. But I think that's, we need to be kind of aware of these and make sure we're dealing with the retired cases, and then we get the dismissed disposition so that we can use our form and expunge these cases. There's also, particularly if you see a probation violation, I think it's a good trigger to make sure that we check for attachments. But these little attachments, and you might see them in counties that use the party detail reports that like Madison County does. You might see these like this. I think more often you're going to see it listed as a separate. It'll be like as if it's another charge kind of attached to the record that you're looking at. But we want to make sure we expunge those, because if you don't expunge those, they're going to show up on someone's record. They're going to indicate that there were records there, and they might kind of defeat the purpose for folks. So we want to make sure we capture these when we're expunging these. And again, if you see like a probation violation on someone's record, that's like an indication that there might be one of these on there that you want to make sure you expunge. And this is what you would do with the form, is you just make sure that you put the attachment on one of those charge lines, so that gets expunged with the rest of it. All right, diversions. So we talked about, we have our 3 buckets. Up until now, we've been talking about our dismiss bucket, the form we use for that. Diversions, we're going to use the same form, assuming that someone successfully completed their diversion. It's just a little bit different. But what is a diversion? There are technically 2 types of diversions, but essentially it's a situation in which someone has agreed to do something or not do something. Maybe it's an anger management class, maybe it's stay out of trouble, comply with some sort of probation program for a certain amount of time, whatever it is, there's some sort of requirement. And if you successfully complete those requirements, then you can come back to court and ask the court to dismiss the case against you. There are a few differences with this and how we're going to expunge them, but essentially we're promising to do some things. If we do them and we're successful in them, then we can get it dismissed. If we're not successful, then it can wind up as a conviction. They can come back to court and enter a conviction. And it just depends on the kind of diversion, how much work the DA might have to do in order to get that conviction. But assuming someone has successfully completed, you may see on the record that this case has already been dismissed, and that's the person successfully completed their diversion. I think what I see most often is the dispositional read diversion on a case. And I think in most of the counties I practice in, I've got to go do some work. I've got to go pull some records, talk to some probation officers, kind of see what happened, often maybe a decade ago, To see whether or not my client successfully completed the diversion, have to go back to the court, show the court that the diversion was completed, and then get the case dismissed. A lot of counties don't have, sort of an automatic process for this, so watch out for that. You may have to go back to court and ask the court to dismiss it so that you can expunge it. But some counties helpfully kind of maybe it's been dismissed and it'll show up on your the records that you pull. What's different on the form for diversions is you have a diversion date. And that diversion date is whenever the case was dismissed. So the date that the court said, yes, I see that you completed your diversion. I am going to dismiss this case for you. That is your diversion date, and that's the date that you're going to put on this form. And then I want to flag at the, sorry, did I miss something, Joy? Okay, cool. And then I want to flag at the bottom that the diversion box doesn't say diversion. I think the rest of our boxes are pretty helpfully marked and say what they mean. But our diversion boxes don't say diversion. They say that you successfully completed your requirements. So watch out for that. But otherwise, though, you can use the form in the same way. Two other things. Okay, I'm gonna. Two other things with diversions. There's a $100 fee attached with expunging diversions for dismissals. There is not a fee for expunging. They're free. But we do have to pay a $100 fee to expunge a diversion. Some counties will waive that. The other thing is that some cases are not eligible for diversions, whereas before, as of right, you can expunge things that were dismissed. If you served a diversion on some sexual offenses, that you're not going to be able to expunge those. Partial expungements, we call them partial expungements. Really, these are records that are going to be removed from some sort of online database. And they've got a special form for that I'm going to show you really quickly. It looks like this. And if you go to the TBI's website, they've got all of these different forms available for you. The difference for this, it asks for a little bit, and partial expungements is where a dismissed case is tied to a conviction. So if there's a conviction under the same docket number and there's a dismissed charge on that same docket number, this is the form that you'll use. And really, my understanding is that it asks for the same information, but this form is supposed to flag that there's a conviction tied to the case that is not being expunged, and it needs to flag to everybody that's destroying records that some records of the conviction may need to be kept. So, all right, I think we are wrapped up on our diversions and our dismissals. Joy and I will hand it over to you. Stop sharing.
All right, I am super, super excited to move us from, I'm pulling up my screen for you all, to move us, for some reason, it is, hold on, not showing me the Google. Give me 1 millisecond, y'all. I promise we practiced this too. Okay, take 2, share screen. Okay, I think I'm now, does everybody see the shared screen? I'm going to start the slideshow at the slide. Yes, okay. So now Savannah introduced us to the heart of what all of us will be doing when we do expungement, which is to get dismissals and diversions off of someone's record, because quite frankly, those are all over folks' records. And I think that part of the problem is that many people think that dismissals and diversions are automatically removed once they're entered because, I don't know, makes sense, right? The case was dismissed, but they don't unless you file that petition. And so that is a piece of this that I think is just such an important part of our work, and oftentimes is, a chunk of the work that we do in expungement clinics. The biggest reason why dismissals and diversions are in different buckets on our 3 bucket chart is because the diversion has the diversion fee. And I know Savannah mentioned that. I just wanted to make clear that that's the major distinction. The same form is used for both. Then when you get to convictions, you are actually talking about filing a petition that is discretionary. And so the other nice thing about both dismissals and diversions is it's not discretionary. You filed out that petition, provided you put all the information in it that you needed to, and it's correctly filled out. It is often signed by a DA, definitely needs to be signed by a judge. The order is entered, the charge is expunged. Convictions are a little different, and they really do, in my mind, require legal analysis. And so really knowing how the conviction statute is structured will help us, which is why I highlight that there are different sections. So we're still in that 26-page 101, 4032 101. In 2012, just a little bit of history, was the first time Tennessee began to expunge or talk about conviction expungement. So although we had a history of allowing people to expunge dismissed cases, dismissed charges, actually expunging convictions, it was a big thing in 2012 when we started to say, okay, we are going to look at convictions and look at what convictions we want to identify as expungible. At the time, though, super limited. So you could expunge one conviction, and that could be basically the only conviction on your record. And so that was the origins of conviction expungement. Since that time, I think Vandy Professor Kara Suval has identified 20 changes to the expungement statute since 2012. And so in the past decade, we have change the statute, which really is why we really try to do these types of CLEs almost every year because they're needed. You look at the 2022, 2023 changes and the right-hand column and you think, oh my gosh, no, this CLE is going to summarize quickly so that you can just put in your head kind of how this part of the statute is structured and then apply it to the case that you have in front of you. So let's get started. There are 3 questions that I want you to always think about answering when you're talking to a client about whether a conviction it can be expunged. The first analysis you have to do is this conviction on the record even eligible for expungement? We're going to talk about how you determine eligibility, but if it's not eligible, then you have actually you move in terms of thinking about this as a decision tree. You have a different part of the decision tree to think about. So first, is it even an eligible conviction? Is it something that the statute, the legislature has contemplated that we would like to allow people to expunge? The second question is it expungible? Wait, Joy, if you just told me I'm going to answer that it's eligible, why am I now answering, is it expungible? There are reasons. And so you want to separate those 2 questions so that you don't conflate the 2 answers. So a conviction can be expungible, but for example, there's a waiting period. So that's one just quite a small glimpse into how you might have a difference between the answer to what's eligible. Yes, that theft charge is eligible under the statute for expungement, but can I expunge it? Maybe not if 5 years hasn't passed since the time that misdemeanor has expired. And so just to give you a sense of why these 3 questions are important, is it eligible? Is it expungible? And can I expunge it now? In G, one of the first things that G did was outline eligible convictions and how to determine whether a conviction is eligible. And it does it for convictions before 1989, which has a separate way of doing it. I'm going to describe that quickly. And then it literally lists convictions for misdemeanors that are ineligible and for felonies that are eligible. So here we go. All right, strap in for, is the conviction eligible? For before 1989, again, just a little bit of history so you understand why there's this difference. Before 1989, our criminal code was structured differently. Crimes were called different things. We had a complete overhaul of our criminal code and how we actually criminalize different offenses, both in terms of different levels, different names. And so if you look at older charges, they might have, you might see a conviction for dangerous drugs, right? That is no longer the way we talk about drug crimes after 1989. And so for pre-1989, which oftentimes our clients have convictions that are much more recent than that, but pre-1989, you are going to, there's a criteria 4 potentially eligible convictions. So you really have to look at the statute and look at that criteria. Just to give you a sense of what that criteria looks like, you are going to have to first identify that the person that you're helping has not had a previous expungement of diversion. That rule only applies to pre-1989 convictions. After that, you have to determine whether the offense for which the person's convicted did not have or was not one of the following. Okay. So, for example, just to go through a couple bullet points to give you a feel for it, is there an element in the conviction that you're looking at of physical force against another? Did it result in death, serious bodily injury, or of a person? Did it involve a minor as a victim of the offense? So for pre-1989, I'm just going to leave you with the thought that you really have to go to the actual statute that determined what the elements were for that crime, and then compare that information and what the person was convicted with this list of bullet points. One example of a pre-1989, and honestly, I haven't done many of these, they don't come up that often, was somebody who was convicted of a theft crime that when you looked at the charge on her criminal history, she was charged with a theft crime that was over $60,000. So it was, I think, $120,000. If you look at the last bullet point, the result of loss has to be 60,000 or more. So in looking at that client's conviction, at first blush, you'd say, okay, 120,000, that's more, double 60,000. But when we looked at the client's actual judgment, it turns out that she only pled to a conviction of theft of, I believe it was around 45,000, and then paid restitution on that. And so we argued under this criteria, she didn't meet any of the other elements, the drug elements, the violence elements. And so she was eligible for expunging that conviction, and the DA agreed, and we expunged it. But for pre-1989, that's the hardest type of conviction analysis in terms of eligibility you're going to have to do, because the statute gives you a cheat sheet. The statute tells you that for misdemeanors, I have a big thumbs down, because you don't want, there's a list of about 24 misdemeanors. You don't want the misdemeanor that's on your client's record to be on that list, because the statute under G1B lists misdemeanors that are not eligible for expungement. So you literally have to look at the list. This is just a preview of some of the initial ones that are on the list. And it's important to note that there are some that are pretty prevalent misdemeanors. I point out domestic assault. There's also ineligibility is a misdemeanor of DUI. So those are things that oftentimes we'll see on our clients' records, and we can know just by seeing that those are misdemeanors that are not eligible for conviction expungement. For felonies, we want to find it on the list. I literally tell my students, you're looking down the list, comparing your C, D, or E felony to that list, hoping that that conviction's on there, because the statute lists eligible convictions. So although it gives you a cheat sheet, you just have to remember the ineligible, eligible difference. Misdemeanors, they're the ones that we are not going to allow people to expunge. But for felonies, they are the eligible felonies that people can expunge. Again, just look at your statute as a cheat sheet. And I know Andy's provided you with a list of these these expungement provisions in the little what would we call it, guide that you've produced for them. And so the cheat sheet in the statute is actually in that set of materials that Andy has given you. Eligible felonies, there are E felonies that are eligible, there are C felonies that are eligible, and there are D felonies that are eligible. So it's been pretty exciting over time. We started out just with E felonies that are eligible. Some of them are going to also appear frequently. Theft, drug crimes. You're going to see that the eligible felonies that the legislature has felt should be expunged, or we should allow people to expunge after November 1st, 1989, are felonies that are pretty much crimes that are crimes of monetary crimes, victimless crimes, no crimes of violence. Extortion, forgery, criminal simulation, worthless checks. For many of our clients, these are the types of crimes and convictions, though, that keep them from getting jobs. And so oftentimes I'll look at a record of a client, and they'll have a simple possession conviction and a theft conviction. Which one do you think that they would like expunged from their record? The theft conviction, of course, because that often has, as a crime of dishonesty, as a crime that an employer does not really like to see on somebody's criminal history. All right, so let's take a look at an example. Back to Bill Smith. We've already expunged all of his dismissals. So if you look at this criminal history, this is the criminal history that in the way that Knox County presents it for the purposes of evaluating. I think that this is a nice format to look at, because if you look at his criminal history, what do you see? You see that there are a bunch of dismissed cases. And this is very typical in terms of looking at our clients and being able to say, okay, I'm going to file a petition. There's that word nolle prosequi, the Latin phrase that means fail to prosecute. The idea behind filing those petitions and filing them quickly is that you can get them expunged. They're not discretionary. So for Mr. Smith, he has one docket number with a conviction, and he has a theft and a theft by shoplifting, 2 counts. He has one that's a conviction, one that's a dismissal. So just bringing us back to Savannah's presentation, this would be a partial expungement. All of these dismissed cases and this diversion, this completed by judicial diversion, we're all going to be filling out petitions for. And now we're going to have to analyze this conviction. This is a misdemeanor conviction. And so what do we want to do? We want to go to our cheat sheet in the statute. We want to look to see if misdemeanor theft is on there. Do we want to find it on there? For conviction expungement? No. If it's a misdemeanor, we don't. I'll just give you a hint. Theft is not on there. So for Mr. Smith, the beauty is when you first look at this record, it looks impossible. But the result is that you would be able to expunge everything on his record, including his conviction. So under G, there are certain additional things that you need to know. And this is probably the most complicated part of the session. This part of G was added in 2022. So one of the newer parts of it, it says a person has not been convicted of a criminal offense that's ineligible for expunction, including federal offenses and state offenses in other states that occurred prior to the offense for which the person is seeking expunction, provided that moving or non-moving traffic offenses shall not be. Oh my goodness. I'm going to break this down for you, because although these many, many words might seem very confusing, in reality, here's how you can think of it. First, if you have eligible convictions, so that's why you first have to look at convictions and say, are they eligible? So I have 4 convictions on someone's record: simple possession, paraphernalia, theft, and a DUI. The first question is looking at those 4 eligible versus ineligible. That example, the first 3 are eligible, the DUI is not. So what the 2022 change says is that you can expunge an eligible conviction, provided that it occurred before an ineligible. So one of the things that we'll do in class is that we'll look on people's records for convictions and try to see if they have any ineligible. Because that, by finding the ineligible conviction, then in terms of conviction expungement, you'd look to all of the ones before to determine whether there's any ability to expunge the ones that happened before an ineligible. Another part of that G2 a little I is that it says excluding moving and non-moving traffic offenses. What does that mean? Good question, because the statute does not define moving and non-moving traffic offenses. So every once in a while, we'll have arguments about this, but the bottom line is if it looks like something that is a traffic offense, speeding, driving on a suspended license, broken taillight, you don't include that in your evaluation of offenses. And so when somebody has a criminal history like this, driving without a valid license, passing in a no passing zone, theft, roadway violation, which one? Take a look. Are any of them moving or non-moving traffic offenses? This is where I wish I could call on people. Andy didn't give me that power. So looking at it, driving, yeah, that looks like a moving or non-moving traffic offense. So don't include it in your analysis. Passing in a no passing zone, again, driving offense, don't include it in your analysis. Roadway violation, theft is really the only conviction that would be defined an offense under G. Then G1F says that conduct that occurred contemporaneously at the same time represented a single continuous criminal episode with a criminal intent, and all such convictions will be eligible for expungement under this part. So in plain English, let's see how this works. When you have multiple offenses, multiple convictions that all emanate from the same episode, the same criminal episode, which includes intent and basically location, you could think about it this way. I get stopped by an officer. The officer finds marijuana and paraphernalia. I get convicted of marijuana and paraphernalia. That's a continuous contemporaneous event. Same criminal intent, same location. It meets all of the elements that we showed you in this slide, and they would be considered one offense. So when we take a look at the moving and non-moving offense exception, we look at F, and we look at the fact that we can now expunge eligible provided that they occur before ineligible. We really expanded the statute in a tremendous way. All right, so let's look at Martin Smith. I know we're picking on the Smiths today. These are all made up documents, not actual clients. We see driving on privilege suspended. That's dismissed. We don't even have to say that it's not an offense. We get it off with the petition. Same as the resist, stop, and arrest, which was also dismissed for failure to prosecute. Simple possession, now we have an actual misdemeanor conviction that we want to analyze. That's eligible. Disorderly conduct was dismissed. Get that off using the petition. Domestic assault, it's a conviction. So we have 2 convictions, simple possession, domestic assault. What are we going to do? We're again going to look for the ineligible. I told you domestic assault is not eligible. So then we can look to the ones that are before domestic assault and expunge the client's simple possession. So K got exciting. So when K was passed in 2017, we went from allowing somebody to expunge 1 conviction, which, as you were hearing, that's all we were talking about under G, 1 conviction expungement, to saying up to 2 could be expunged. But wait, there's limitations in K. We're hoping those limitations change based on a bill that has passed both subcommittees in the House and is now on to finance. But until that statute passes, this is how K reads. No more than 2 offenses. So we're not even sure, query, does moving or non-moving traffic offenses apply? There's some case law out there that says no. So when we look at K, the most strict interpretation of K says there's no more than 2 offenses, full stop. So if I have a simple possession that's eligible and I have a theft that's eligible, and that's my client's entire record in the whole entire world, I can expunge under K their 2 eligible expungement convictions that I can help my client with. Because the second prong says you look to G to determine, so you look to your checklists, your conviction checklists, to determine if they're eligible. But they have to be in this framework: 2 misdemeanors or 1 eligible felony and 1 eligible misdemeanor. So if you have 2 eligible felonies, which I have a client right now, and that's the situation, and it's heartbreaking for me, 2 eligible felonies cannot be expunged under K. And it's clear, based on an addition made in 2022, that the person may petition for expunction of these 2 offenses under K only 1 time. So a person can't keep using K as a relief mechanism. How does this look? This individual, Teddy Smith, has a conviction for possession of drug paraphernalia and vandalism, and 1 for domestic assault. Nope, not a conviction. It's a dismissed case. So we're going to file a petition and get that off. We're going to look at the 2 that are remaining, and we're going to say under K, these are 2 eligible misdemeanors that falls under all the criteria. And we just have to make sure that it meets all of the waiting periods and process parts of the statute, which I'm going to get to. I'm going to run through a couple things very quickly just to say H. Section H applies to pardons. So if you have a client with a pardon, and I've done one of these, so I'm happy to help, the pardon part allows you to expunge pardon convictions that are nonviolent. I want to talk to you about that because you first have to do a petition to show that they're nonviolent crimes, and then you can do the petition for expungement under H. I have samples of those if anyone would need them. I'm sure Andy does too. Then more recently, in addition to H, we added M and O. M allows us to, it's very, very specific, a conviction expungement part of the statute. It's for somebody who's been convicted of a violation under 219-107 for illegal registration or voting. It gives a 15. If you have that particular conviction, just look at M and read M. O allows persons to expunge an arrest record if the conviction is not on record and never emanated in court. And so oftentimes the person was arrested, there's no history in the court records, we didn't know how to expunge it until O was added. 4032-105 is our human trafficking conviction expungement part. It is very complicated. If your client has a conviction as a result of human trafficking, you have to go to this part of the statute. Kira the Suval, who is the Vandy professor who I've mentioned, is an expert. She's done a ton of this. She actually has a guide that we could share with you that kind of walks you through how to expunge these. I'm not going to get into detail about it now because there's more that I have to cover. But if you have a human trafficking conviction, this is the part of the statute you go to. Waiting periods. So once you finish that first question of, is it eligible? Then you go to, is it expungable? So you got to look to the parts of G that tell you, is it eligible before and ineligible? You look to the parts of K that tell you could do up to 2 and how to do it. Then you have answered those 2 questions. Now we have to answer the question of, can I do it now? There's a 5-year waiting period for eligible misdemeanors and E felonies and a 10-year waiting period for eligible C and D felonies. If you have K expungements, those waiting periods start right now. We're hoping that will change too. They start at the most recent conviction that you're looking at. So if you have let's do a C felony and a misdemeanor, and the misdemeanor was the most recent one, you're going to do the 10-year waiting period check on the misdemeanor. But for G conviction expungements, where you're just expunging one, you can just look to that and make sure that 5 years have lapsed since the completion of sentence, or 10 years have lapsed from the completion of sentence, depending on what type of conviction you have. There are a bunch of other requirements. We're gonna share these slides with Andy so you can use them for reference. You have to pay court costs. You have to have restitution paid. You have to complete imprisonment and probation. And so you want to take a look to make sure your client meets all of these other requirements. They're pretty procedural. And then you file the petition. You file the petition in court. Like I said earlier, it's discretionary, so you file it. Could the district attorney object when they're given notice of it? Yes, they could, and they could file evidence relating to the petition as to why it shouldn't be expunged. There's a process. The court shall weigh the interests of the petitioner against the best interest of justice. There's a rebuttable presumption. That's good news, because the idea is that we don't have to present proof. There's a rebuttable presumption unless we have to overcome evidence that tries to rebut it. Finally, I want to point out section N, which is also a new section and has gone into effect on January 1st. Anytime you file one of these petitions for conviction expungement, the court is going to request a certification from the TBI. So the TBI is producing and certifying that the conviction that you're asking to expunge is eligible. So they're only answering that first question. Is it on one of those lists? Does it meet the 1989 criteria? And that TBI certification would be attached to the documentation that the court looks at to determine whether or not they're going to grant the conviction expungement. I can't do a presentation about expungement without telling you the profound effect that it has on people. And I think that I always want to point this out because our statute does a good job at this. The statute restores the petitioner to the same status occupied before arrest, indictment, information, anything related to the conviction. That is powerful. And in terms of it, you can't be guilty of perjury if you deny that it ever existed. Once the order is entered, no direct or indirect consequences shall generally apply. So for example, if you expunge somebody's felony conviction and that's the only conviction that caused somebody to lose their right to vote or their right to serve on a jury or run for office, they're automatically restored to the position they were in. And so they don't have to do anything to restore those rights. It's as if the conviction never occurred. These are quotes from the actual statute. So is it eligible? Is it expungable? Can you do it now? So in terms of actually helping clients, let's take a look at Bridget White's case just to kind of review what we did and see if you'll be able to successfully apply it at the clinic that you have with Andy, and I know you will be. We're going to take a look at this record. Take a look for a second. We have 2 dismissed cases and a conviction. Theft, we've gone over, is expungible. So is it eligible? Yes. Is it expungable? It's the only conviction on this person's record, so Yes, yes. And can I do it now? Anything that happened in general sessions court, the most that they could have as a sentence is a year. So the year would, when this person would be have completed their sentence is 2010. Have 5 years passed since then? Yes. So that's like the actual application of how you take each of those questions and apply it to a person's record. And I know all of you know that those you'll do petitions for the dismissals because Savannah taught it really well, and you're going to be able to just get everything off of Bridget's record and give her a clean slate, which is the purpose of helping people do this. And I will say our clients are really grateful for that. I'm going to move forward to just take a look at this record. In this record, you have a conviction for a simple possession, which is a misdemeanor, and then you have a felony manufactured delivery of sale. So you have a felony and a misdemeanor. You're going to first, is it eligible? Look them both up. Are either of them ineligible under the statute? No. One is on the felony list, the other one's not on the misdemeanor list, so can expunge them. Under K, you can expunge up to 2, misdemeanor and felony. This is like your perfect client with that example. And then you're going to look at the waiting periods. Can I do it now? For the 2014, you have to take a look, serve 2 years, 14, 15, 16, add 10 years to 2016. So the biggest problem for Mr. White is that he just has to wait until the end of his waiting period, which would be 2026. And so he'll be able to expunge both of these convictions after that. Could he choose to expunge the simple possession? Yes, but I suspect that he would want to expunge both of them. So are they expungible? Are they eligible? Are they expungible? And can I do it now? So when you take a big picture look at everything we've talked about, we're looking at, are there expungible dismissed cases or diversions on my client's record? Are these expungible and can I do it now? And then are there any barriers? Savannah talked to you about the diversion fee to expunge a conviction. There's a $100 fee in many counties. I can't remember whether that's the case for the county that you'll be working in, but I know Andy will tell us. Is there a waiting period that hasn't elapsed? So you want to just take a look at what those 3 questions to kind of overall check yourself on the person's criminal history. And so this has been a big push for the TBA Access to Justice Committee to take a look at some of the problems we found in the new changes. And some of them I've identified, like do moving or non-moving traffic offenses count in K? Some DAs are questioning what that eligible before and ineligible it means. I just wanted to flag for you that we've been working on this. We've been trying to educate individuals throughout the country, DAs, judges, lawyers, so that they know about these changes and understand how to apply them. And excitingly, we have worked on a bill. Representative Doggett introduced this bill. We have a sponsor in the House as well. And if this bill 2686 passes, we're going to fix some of the expungement problems that I've raised in this presentation. And so hopefully Andy will invite us back so we can tell you about those changes in July. Other than that, I think that Savannah, I'm going to turn it over to you because we've also been recruiting pro bono attorneys for another project related to this, which is voter restoration. Savannah, take it away.
Just really quickly, y'all, I know we only have a few minutes left, but there's been a lot of changes to kind of the rights restoration landscape that impact a person's ability to restore their right to vote after a felony conviction. I think on the next, we'd love to talk to you more about this. There's a whole lot going on, but it's a really big deal. It's impacting Tennesseans, I think, on a much bigger way than it impacts folks in other parts of the country. This QR code, you can use it to sign up to learn more and to also become a volunteer on our rights restoration project. We are connecting folks with criminal records that want their rights restored with pro bono attorneys across the state, and we would really love to have you and to talk more about kind of the landscape in Tennessee, how it's changing, and what we can kind of do to help folks. So, Joy, is there anything else you'd like to add on that one?
Perfect.
Perfect. Thank you all so much. We've got a couple minutes. If y'all have any questions for either Joy or Savannah, go ahead and put them in the chat. In the meantime, what I'm going to show everyone really quickly is kind of what our clinic process looks like. So basically, people will call our office and register, which we already have over 20 registered for this upcoming clinic. And then we pair these clients up with attorneys completely virtually. So all you have to do is make a phone call to the client, and I'll share my screen now. And we use document automation software. We have one for non-convictions and one for convictions. And basically, you will call the client and you'll either ask the information that's on here, or you can pull a lot of it from that party detail report. But I will just use my name as an example. Um, um, and we'll do Madison Sessions. And once again, most of this information is going to be on that party detail report. If not, the client will know a lot of it. There's only one, type this in. It's dismissed. And then you hit continue. And then you review it. And that quickly, once it thinks for a minute, you will have your expungement order ready to file with the court. So it's that simple. That took probably 2 to 3 minutes to complete the form. So we do try to make that as easy as possible. There are some, that's Joy posted that in the chat. Does anybody have any questions at all?
I think Tara has her hand raised.
I can. Hey, Tara, you should be allowed to unmute and speak if you have a question. There any questions at all? If y'all have any questions or you're interested in the restoration project, feel free to reach out to myself. Joy just put her email address in the chat. We do have a few clients from WTLS who are in that project that we are pairing people up with currently. And Savannah, you just shared your email address only with me and Joy instead of everyone. Don't worry, I do that all the time. But thank you all for joining, and please complete your CLA form and get back to me. And in the meantime, y'all have a good holiday weekend. Bye.
Thanks so much.